In this fourth of my series of Carlyle lectures, I turn from the land to the sea. And my lecture is called Captain Kidd, Piracy and the Sovereignty of the Seas. In 1696, an English government official announced, "Suffer pirates, and the commerce of the world must cease." Pirates disrupted trade, destroyed lives, stole property, provoked foreign powers, and defied sovereign governments. The commercial value of transoceanic merchant ships was enormous. Among Locke's papers is an interesting inventory of an inbound ship to London, just arrived from the Indies, very richly laden. Valued at the enormous sum of £200,000, and which contained over 40 kinds of textiles, which are enumerated, names of which many were recent additions to the language, such as chintz. Such inventories are an index of the roaring consumer demand for fine textiles from the Indian subcontinent. The scale and audacity of piracy was breathtaking because the stakes were high. If the earlier phase of the so-called golden age of piracy was the 1670s and had its locus in the Caribbean, by the 1690s what confronted the Board of Trade was a new locus in the Indian Ocean. Piracy was entering the popular imagination of the time and became a highly contested phenomenon, economically, legally, morally. Of the many contemporary books about pirates, Locke owned 2 illustrated editions of one of the most famous, Alexander Esquemelin's Buccaneers of America of 1684. There was another crucial primary text, which I'll come back to, which all modern histories of piracy plunder, which was published 20 years after Locke's death. It's called The General History of the Pirates of 1724, often attributed to Daniel Defoe. We'll see that it's a book shadowed by Locke. Piratical predations in the Indian Ocean and the Red Sea were deeply damaging to the East India Company. In 1695, Captain Henry Avery, sailing from Madagascar, and Madagascar is an important part of our story, seized a valuable ship belonging to the Mughal Emperor Aurangzeb, one of the world's most powerful rulers. Aurangzeb threatened retaliation against the company, and the company, to conciliate him, began to escort Mughal ships. The company in turn put pressure on London to act against the pirates. And one of the earliest documents signed by Locke at the board was a draft of a royal proclamation ordering for the search and seizure of Captain Avery, who had sailed his prize to America. The Board of Trade went on to a highly orchestrated and aggressive campaign to suppress piracy, militarily through naval action, judicially through prosecution and exemplary punishment, and prudentially through offers of amnesty. In 1698, the board orchestrated the sending of a naval squadron to Madagascar with orders to secure the trade of those parts and clear the seas of piracy by an utter extirpation of them unless they immediately surrender. And Locke gave close attention to the logistics of this expedition. One historian of the East India Company writes that such a role for the English state in Asia would have been unthinkable earlier. Later, in 1699, the board recommended the stationing of another squadron in the Caribbean, so that by 1700 there were 3,000 men aboard naval ships, royal naval ships, cruising the oceans, policing what henceforth were called was called the freedom of the seas. This peacetime use of naval squadrons to project sovereign authority over the oceans was unprecedented and would last for the duration of the British Empire. And yet, piracy is and was an ambiguous category. And debates about the meaning of piracy went to the heart of some elementary questions in political theory. Piracy is not a categorical entity. Piracy is the illicit violence on the high seas. But the power to determine what's licit and illicit is an epistemic, juridical, and political power. Piracy is action outside the boundaries of states on the high seas. But it is what a sovereign state or collectivity of states declares unlawful. We have here another Weberian crux. If a state is defined as the monopoly of legitimate violence over a given territory, what of violence beyond a state's territory? What is the relationship between state and non-state actors on the oceans, which do not belong to any state? Locke sends ships with guns, but he's also engaging in juridical empire, the shaping of a sovereign determination of who and what counts as piracy. In his time, the most obvious way in which piracy was ambiguous was in the general practice of privateering. In the early decades of empire, monarchs and colonial governors commissioned private owners and captains of ships to engage in violent pursuit of profit and superiority across the seas. Much of proto-imperialism was conducted by privateering. Sir Francis Drake and Sir Walter Raleigh were private marauders with royal licences. Their royal commission was the alchemy of imperium, which turns them into quasi-state actors. A spectacular example later is the East India Company, which by the 18th century was a company state, behaving as a quasi-sovereign, including its use of coercion, under licence of its royal charter. The early modern state was a hybrid, on the one hand seeking to pull jurisdiction and governance in towards itself, but nonetheless at the same time still very dependent on outsourcing jurisdiction and coercion in what we may call public-private partnerships. During wartime in the 1690s, privateering was put to use to augment the limited resources of the Royal Navy. Private merchant ships were licensed to attack French ships, and in turn, English merchants were ravaged by France's own successful campaign of privateering. There were huge shipping losses to the French. One wealthy merchant, Samuel Heathcote, wrote a long letter to Locke, pressing him to persuade the Admiralty to hand out more privateering commissions, for he himself had a ship, 24 guns, which he wanted to deploy. After the temporary peace of 1697, a so-called pirate was often an out-of-work privateer who'd had his licence withdrawn by the government. So piracy is marauding not licensed by the state. And when a state aimed to destroy piracy, it was not only deploying firepower, but engaging in the constitutive construal of certain actions as illicit. And in much recent theorizing, piracy is the very antithesis of sovereignty. This Weberian thought has prompted a substantial literature accenting the character of piracy as a legal fiction, in which piracy is figured, to use a different scholarly image, figured as the other, the opposite of legitimate statehood. A thing is defined by what it is not, sovereignty, piracy. Consequently, early modern piracy has become a kind of vortex in political thinking. And I also want to suggest links between piracy and the ways in which Locke, in the two treatises, conceives of tyranny and the rights we have against it. Now, some of the recent literature falls within the emerging subdiscipline of the history of international law. The development by which, in the writings of Alberico Gentili, late 16th century, Hugo Grotius, mid-17th, and Emeritus de Vattel, mid-18th, the net of jurisdiction began to be cast upon the oceans. This is now augmented by literatures indebted to Schmidt and Agamben, arguing that piracy was the archetype of the lawless violence that the state promises to erase. Piracy becomes here a state of exception to refer to the ways in which the powerful, the state, seeks semantically to construct and criminalize their enemies. It's tempting to say that all these theses are variations on St. Augustine's story in Book 4 of The City of God, about Alexander and the pirate. Both are plunderers, but one of them has the powers and dignities of political authority. Compare Locke's own remark in the second treatise, paragraph 176. The only difference is great robbers punish little ones, and the great ones are rewarded with laurels and triumphs. Given the recognition of the artificial, constructed nature of piracy, and given the explosion of recent literature on the subject, it's worth briefly sketching here two further models in the literature for understanding piracy, both of which reject the easy assumption that piracy is simply barbarous criminality. Now, these two models rely heavily for their primary evidence on a book I mentioned earlier, The General History of the Pirates of 1724. This takes us back to Madagascar, which looms very large in 17th and 18th century travel and imaginative literature. It is, for example, the site for the Republican Henry Neville's utopia, The Isle of Pines, of 1668. The General History of the Pirates of 1724 describes the creation in Madagascar by pirates of a free state called Libertalia, whose citizens are known as liberi, a designation which, we are told, supersedes all distinct identities such as French, English, Dutch, Africans, etc. The liberi, it is claimed, held that every man was born free and has as much right as another to what he needs to support himself. They believe in a natural right to the share of the earth. They believe that the origins of government lie in the recognition that men's passions blind them to justice and make them partial to themselves, and so they ought to submit their differences to disinterested persons. The liberi abolish slavery, since, quote, trading in those of our own species is never agreeable to justice, and it was unconscionable for someone who asserted his own liberty to go about to enslave others. Here is a putative description of a libertarian pirate state that has abolished slavery. Now, all of this in the 1720s seems manifestly not to be reportage, but rather a projection of English Whig idealism to the tropics. This is a utopian reading of Locke transported to the Indian Ocean. We can find a Whig gloss on piracy of a rather similar sort much earlier, in the 1698 preface to Esquemelin's Buccaneers of America, the book that was on Locke's own shelf, where the author asserts that it is very remarkable that in such a lawless body as these buccaneers, lawless in respect of others, yet they form among themselves a regular society in which what they have made their property is secured, as if they were members of a civilized community. Here we have an intimation of a different kind of libertarianism, of a pirate quasi-state that secures property in the pirate's ill-gotten gains. And it's certainly the case from other sources that were many pirate articles of agreement which implied codes for mutual conduct, governance of a sort, and rules for the distribution and security of the property they've seized. Now, on the basis of this and similar material, one recent scholarly tradition, a Marxian one, wholly decontaminates piracy, identifying pirate societies as, if you like, countercultural subalterns of the seas. On this account, pirates are subverters of the rapacity of nascent merchant capitalism and of the states that protected it. This extrapolates C.B. Macpherson's classic reading of Locke as an ideologist of early capitalism, such that Locke's own hostility to pirates, to these sea-born subverters of capitalism, becomes predictable. A second strand of literature uses the same primary sources but reverses the orientation and finds in the Buccaneer Commonwealths paradigm cases of Lockean polities now construed in a Nozick'ian way. That is to say, in the spirit of Robert Nozick's reading of Locke in his book Anarchy, State and Utopia. On this account, pirates create microstates out of an oceanic state of nature, and through their social contracts construct a minimalist polity for securing elementary public goods, particularly the protection of property, while maximizing the self-interested pursuit of their private advantage. One book in this libertarian tradition has a very clever title indeed, The Invisible Hook, a pun, of course, on Adam Smith's metaphor of the invisible hand. Well, the most recent historical works have put paid to the utopian readings of piracy by showing just how well integrated Madagascar pirates were into transnational economic and social systems. In particular, Indian Ocean pirates were integrated into American colonial societies. The colonies harboured, supplied, and traded with pirates, partly to evade English trade restrictions. In fact, one strand of writing sees piracy as a response to imperfect markets, a sort of extreme form of monopoly busting, monopolies in the chartered companies and in the restrictive trade rules of the English state. The close connection between Madagascar pirates and colonial American society brings us back to Locke and the Board, which waged a prolonged campaign against the colonists' own illegal trading, their harbouring of pirates, their evasion of the navigation laws, which constrained commerce within the English mercantile orbit. Now, reading Locke's own documentation, it's difficult not to see him as a prime agent of an English state seeking aggressively to control the meaning of piracy and to legitimize its suppression. There's no ambiguity in his language. He declares piracy a thing heinous and pernicious and in need of extirpating. There is, he wrote, nothing more prejudicial to trade, and it's a thing of fatal consequence. He signed a letter to the governor of Maryland applauding the zeal which you have for the extirpation of that pernicious race of vermin. And that governor personally commanded a 10-hour sea battle against a pirate ship in which 26 pirates were killed and 52 more captured and hanged. Locke's instructions to the squadron that was ordered to sail to Madagascar refer, again, to the utter destruction and extirpation of pirates. And in other documents, he condemned the slippage between the words piracy and privateering. He's aware that privateer had become not so much a technical term for commissioned ships as a euphemism for piracy, especially among the colonists. Privateers, he writes, is a soft name given to pirates. It seems clear he wished to eliminate privateering, in its strict sense, to favour state actors as the sole authorised users of coercion. But as we shall see, he also supports private actors at sea, which complicates the picture. The Board of Trade attempted to persuade all the American plantations to replicate the Jamaica Piracy Act of 1681, which allowed for the death penalty. Frustrated at the colonies dragging their feet on this, the board recommended that the English Parliament pass legislation. And this resulted in the Piracy Act of 1700, which empowered 7-member Admiralty commissions to try and execute pirates anywhere without juries and by majority vote. The board furthermore urged colonial governors to send the worst offenders to England for prosecution, together, he says, with the evidences that may be of use for their conviction. He wished to see more hangings. It's not clear whether his preference was for trial in England or the plantations, ideally in the plantations. But until they have passed sufficient penal legislation, then the main culprits should be sent to England. There is a short paper of his surviving, of 1697, called Of Pirates, and it contains a further proposal that is very striking indeed. The paper's addressed to the diplomats currently assembled at The Hague to negotiate the Treaty of Ryswick. And he suggests here that all the princes and states should offer a general amnesty of 6 months, during which pirates are to surrender themselves to their home countries. And those who defy this deadline shall, by the joint force of all the said princes and their allies, be prosecuted to the utmost parts of the world. Locke's notion of joint force, having global jurisdiction, is arresting. I don't think he means an international tribunal. What he means, though, is the collective action of states. And I think his proposal is grounded in a long-standing argument from Jus Gentium, that states are collectively responsible for enforcing common norms of justice. The notion flows in turn from a rather loose neo-Stoic idea of the common obligation commonwealths have to uphold universal norms of humanity. And I think we can construe this also in relation to an idea familiar to us from Locke's second treatise, what he calls the executive power of the law of nature. A power which anybody and everybody has to act judicially retributively against the enemies of mankind. In the second treatise, Locke holds that individuals in the prior state of nature, or when propelled back into the state of nature, have not only a right of self-defense against an attacker, but also a judicial right of retribution. This is the executive power of the law of nature. And states in relation to pirates are to be construed as being in a state of nature, a state of war. The oceans are a state of nature. A pirate, in attacking the property of a citizen of one state, may be construed as attacking property as such, and hence as violating everyone. And so any state or any group of states acting in unison can act anywhere against such enemies. The phrase enemies of all mankind will reverberate through the rest of this lecture for reasons we shall see. For Locke, pirates are violators of law, but less the law of a particular state than the jus gentium that lies beyond particular states. In suppressing piracy, the state is construed as an agent and executive arm of the common law of all peoples. The state provides firepower to universal right. To put it another way, he construes the English state's suppression of piracy as a kind of act of humanitarian intervention. He regards oceans as governed, or at least as governable, by law, the law of nature, so that the oceans need not be regions of anarchy. Piracy is a menace to all, and a state in suppressing it is acting as a kind of patriot for humanity. While Locke certainly advocates and operationalises expansion of the English state's naval coercion on the high seas, I don't think he treats the state as simply extending the arm of English municipal law to ships on the ocean, but rather upholding an idea of universal justice. Certainly contemporaries spoke of ships as little fragments of the English Commonwealth, carrying with them English jurisdiction to the seas. But I want rather to emphasise the role of the law of nations in this thinking. This tricky balance between extending the arm of municipal law and the idea of a law of nations is explored in Lauren Benton's writings, which are key to helping us think about empire upon the oceans. And also important here is Richard Tuck's argument that a good deal of early modern theories of the state extrapolates from the state of nature that is understood to exist upon the oceans. Locke was drawing on a ubiquitous commonplace in early modern jurisprudence concerning piracy. The notion that pirates are hostis humani generis, enemies of all mankind. That Latin tag crops up over and over again in early modern writing. It derives from a remark in Cicero's De Officiis, and it appears to have entered English discussion with Sir Edward Coke in his Institutes of the Laws of England, the volume published in 1644. Lawyers routinely elided, as Locke does, the authorization of the state's extraterritorial jurisdiction, with a primal natural right of individuals to defend themselves and to punish malefactors. Let's take a couple of examples in the legal literature, the literature of Admiralty civil law. Sir Llewellyn Jenkins, in 1668, held that royal justice reaches malefactors even in the remotest corners of the world. But he also states that since pirates are hostis humani generis, enemies not of one nation but all mankind, everybody is commissioned and armed against them. Everybody. Sir Charles Molloy, in a treatise on maritime law of 1676, argues that if you, a private person, together with some like-minded and well-armed friends, happen to come across some pirates on the high seas and defeat them in a fight, then you have a right to hang your captives without more ado, for natural liberty remains in places where there are no judgments, and you may execute such beasts of prey immediately. Places where there are no judgments. Note that the state of nature is a present reality. It exists on the oceans. Molloy didn't intend to exclude the reach of English courts, but he wanted to emphasise that what the courts do is to replicate a primary right of retribution under the law of nature. The closeness of this train of thinking to Locke's own position is, I think, confirmed by remarks made in the middle of the 18th century by that great commentator on the laws, Sir William Blackstone, where he fuses that legal tradition with the second treatise. He writes this: "A pirate, being hostis humani generis, as therefore he has renounced all the benefits of society and government, and has reduced himself afresh to the state of nature, by declaring war against all mankind, so all mankind must declare war against him, so that every community has a right, by the rule of self-defence, to inflict punishment upon him, which every individual would, in a state of nature, have been entitled to do." So again, the community is the executive arm of the law of nature. In the 1690s, there were two very important pirate trials in which the government invoked this doctrine to crush pirates. Captain Henry Avery, whom we met as the perpetrator of the capture of the Emperor Aurangzeb's ship in the Indian Ocean, was never found. He disappears from history. But several of his accomplices were captured and were put on trial in 1696. Much of the trial evidence passed through Locke's hands at the board. The trial had a false start because the first jury acquitted the accused. And since that was the wrong answer, the judges ordered an immediate retrial with a new jury and secured the required guilty verdict. 6 men were hanged. The Attorney General pronounced that the Crown has an undoubted jurisdiction and power in concurrency with other princes and states for the punishment of all pirates and robberies at seas, even in the remotest parts of the world. This phrase, the concurrency with other princes and states, I think is the same as Locke's notion of the use of joint force, which we met in his Memorandum of Pirates. A couple of years earlier, in 1693, there was another trial of pirates, where the issue was rather different, although that phrase, hostis humani generis, yet again occurs. 8 men were tried, of which 2 were executed for piracy. Locke knew the trial judges personally. Their names appear on his lists to receive complimentary copies of books he had published. Now, in this case, the so-called pirates were in fact Jacobite soldiers fighting in the war against the Williamite state. they held privateering commissions issued by the deposed King James II. And the defenders denied that they were pirates and pleaded instead that they were prisoners of war entitled to be treated as such. They had never been subjects of King William. They were Irish. They had fought William at the Battle of the Boyne, and after the defeat of the Irish had been treated as prisoners of war then in Ireland, and had been given amnesties to withdraw abroad. And their lawyers pleaded a different principle of the law of nations, that prisoners of war have a universal right which can't be cancelled by the arbitrary act of the English state. Well, all those claims were intolerable to the Whig state. Since James II had no legitimate claim anymore to be a sovereign, having been deposed at the Revolution, he had no authority to license privateers. The accused were pirates because James was not a sovereign. The civil lawyer who acted in this case was Matthew Tyndall, a close follower of Locke, who in 1694 published two books. One which made use of the two treatises to justify the Revolution, and the other concerning his account of the trial in which he took part, and which he called An Essay Concerning the Law of Nations and the Rights of Sovereigns. Here he blended a defence of the Revolution with an account of the trial. He argues that a prince without a state, James II, is merely a private person. A prince can have no authority unless he embodies a state. Tyndall recapitulates the second treatise. James II was deposed for tyranny, and the people thereby entitled to place the government in new hands. That is what had happened in 1688. And a king that loseth his empire, meaning in the sense of sovereignty, who loses his sovereignty, becomes himself merely a robber or pirate, if he then grants commissions to others to seize goods or ships of another nation. Here we see Tyndall using a crucial rhetorical move, that King James, a tyrant, was not only metaphorically, but literally a pirate, because he commissioned and incited pirates. This dramatises Locke's claim that tyrants are like pirates. Tyndall deploys the standard notion from Grotius that states in respect of one another are in the state of nature, having no common legislative power. But he goes on, amidst much invoking of Gentilly and Grotius, to offer a vision of states sharing the general good of humanity and having a common aim and agency in ridding the seas of the enemies of mankind. Again, a pirate, though attacking the ship of one nation, is in fact an enemy of all governments, because he destroyeth all government and order and breaks the common rules of humanity, honesty, and justice. So he concludes that any state that punishes a pirate is not acting just for itself, but is punishing him, the pirate, as if he robbed all nations. Well, in the second treatise, Locke does use the image of the pirate, speaking of pirates as aggressors who put themselves in a state of war and invade unjustly another's right. And he declares that any honest man may oppose robbers or pirates. He means that any righteous individual may seek to restrain and punish a robber or pirate. To depose tyrants is to suppress piracy. Incidentally, I believe this argument is in part Locke's repurposing of the two treatises, which he had written before the Revolution with domestic insurrection in mind, repurposing it to the circumstances in which his book was published and read in and after 1689, in the wake of William of Orange's Dutch military overthrow of James. Locke construes William's expedition as an instance of humanitarian intervention. A prince, indeed anybody with sufficient power, is entitled to act against somebody who has behaved as an enemy of all. So that the revolution of 1688 on this reading is a war of humanitarian intervention, an act of solidarity in the face of James II's piracy. Now, English people had a famous precedent for this way of thinking, for this was exactly how they construed and celebrated their own intervention a century earlier under Queen Elizabeth I to assist the Dutch in rescuing their liberties from Spanish oppression during the Dutch War of Liberation. This is the background to Alberico Gentili's discussion in 1598 of the right to defend the subjects of other nations against a tyrannical overlord. Gentili, in fact, refers to the great hero, the Earl of Leicester, who had led the English expedition to assist the Dutch in securing their liberties. In 1688, that idiom is flipped over when William rescues the liberties of the English. In the final part of this lecture, I want to turn to the spectacular case of Captain William Kidd, who has the distinction of being one of the most famous pirates in history, and one in whose case Locke was very closely entangled. The Kidd case is complicated because it proved politically a disaster for the junto Whig government and contributed to Locke's decision to resign from the Board of Trade in 1700. The Kidd project began as a Whig project that went disastrously wrong, and so allowed the Whigs' enemies to denounce them and the government as, of all things, a party to piracy. What happened was this. A group of senior Whig leaders, notably Locke's patron Lord Somers and his close colleague in North America, Lord Bellamont, devised a scheme which King William approved of commissioning Captain Kidd to sail to the Indian Ocean and suppress pirates. This was 2 years before a naval squadron was sent. Presumably what was intended was a piece of spectacular popular politics by which the Whigs could be applauded for their own initiative in ridding the seas of pirates. But, catastrophically, Kidd, who was hired to catch pirates, himself turned pirate when he reached the Indian Ocean. There he seized another fabulously valuable Mughal ship and sailed it to America. Governor Bellamont, desperate to recover his reputation, and in the face of this embarrassment, induced Kidd to step ashore and promptly arrested him. Bellamont's Whig colleagues in London, no less embarrassed, ordered that Kidd and his accomplices be shipped to London. The ostentatious punishment of Kidd was now imperative. Kidd and his men were brought over in chains. A dozen were speedily executed, but Kidd himself held back for interrogation and public display. The ship carrying Kidd brought treasure chests and a box of letters from Bellamont to his colleagues in London including letters to Locke. And surviving letters of Bellamont to Locke indeed have plenty of boastful and compromising things to say about Captain Kidd. By this time, the scandal had caught fire in London, and the enemies of the government had a field day, and now called the Whig government itself as a corporation of pirates. They also pointed to the outrageous dubiety of government ministers engaging in a semi-private war against piracy. In 1701, the articles of impeachment against Lord Somers would include the commissioning of Captain Kidd. Under severe parliamentary pressure, the public opening and reading of Bellamont's letters was demanded, including Locke's letters. Locke received a peremptory notice by command of the Honourable House of Commons, send to Mr. Locke for procuring the letters delivered to him by Lord Bellamont. Locke was under the Commons' scrutiny on suspicion of malpractice in public office, even of complicity in piracy, or at least of gross failure of political judgment. The opposition attacked the king himself for allowing the project. The country opposition denounced public corruption and used Whig arguments against the Whig government. One MP declared that the king is a trustee of the people to protect trade, but had betrayed that trust reposed in him. Interesting here, the explicit linkage between trusteeship and trade. A trustee of the people to protect trade. When Locke finally resigned a few months later, he produced a chilly witticism saying that he was the victim of the fluctuating waves of state. Well, my closing paragraphs concern a couple of parliamentary speeches and pamphlets delivered by the Whig government's friends in a desperate attempt to justify the good intentions of the Whigs behind the Kidd project. Sir Richard Cox and Sir William Cooper, MPs, had to concede that Kidd had, of course, betrayed his masters. But they enlarged on the virtuous motives of those who had commissioned him. We have Cooper's speech preserved verbatim in the notebook of Lady Sarah Cooper in the Hertfordshire Record Office. These speeches are a repetition of the arguments and the tropes that by this stage of the lecture will have become familiar. The striking thing here is that the Whig lords are identified not so much as state actors, but as patriots of humankind. So Sir William Cooper asks, what is a pirate? This is his speech in the Commons, trying to defend the Whigs. What is a pirate? He is, hostis humani generis. Who may take a pirate? Well, every man has a right to make war against pirates. Everyone has enough courage and public spirit to undertake it. And everyone has a right to free trade, safe from these spoilers of mankind. The right of a person against the pirate is not only self-defence, but punishment. He may execute such a beast of prey immediately. It's prudent to act against pirates by public authority, but the King's commission is not essential. What the state does is to articulate and reinforce prior right. So these speeches do not so much assert the sovereignty of states as constitutive of jurisdiction over the seas, rather that such jurisdiction is incident upon a prior universal jurisdiction, the common right of justice. What Locke had written about in the second treatise, when he says that honest men may oppose tyrants and pirates. A very final important point to make here takes us back to the idea of office and the overwhelming presence of that book, Cicero's De Officiis. Locke's and the Whigs' appeal to the natural law served to ennoble private individuals themselves as patriots of humanity. In fact, they're not, on this argument, private individuals, because in acting for the public or common good, they are officers, they hold office. And throughout this style of thinking, and I think it's deep in Locke too, there is a kind of Ciceronian sense in which when you act against tyranny or act against pirates, you are acting, even if you are a private individual, in fact, as a public person in the office of the retributor. So that here we find, I think, in Locke's phrase, honest men may oppose pirates, the theme that runs through these arguments. Well, as for Captain Kidd, he was hanged in May 1701, and his body was left to rot in public view, chained to the shore of the River Thames at Wapping. Thank you.